Okay, let's take a deeper dive into diversity jurisdiction. We've been talking about diversity jurisdiction throughout the course, so hopefully this material is feeling pretty familiar, even though we'll be going deeper into it at this point. As we noted earlier, Congress did not pass the statutory predecessor to 28 U.S.C. Section 1331, the Federal Question Statute, until 1875. But Congress did implement Article III's grant of authority to create federal diversity jurisdiction right away in the Judiciary Act of 1789. We've discussed this before. What is the most commonly given reason for this?
To provide fairness to people from out of state who have to litigate in the other party's jurisdiction, because the person from out of state might not be treated fairly.
Good. The traditional reason is that the diversity statute was designed to provide a fair forum for out-of-staters who must litigate on the defendant's home turf, where the defendant might be favored by a biased local judiciary. And recall that many state judges are elected and not appointed for life. They do not have the insulations from the political process that federal judges do. But that said, diversity jurisdiction and the reasons for it have been at least somewhat shrouded in mystery. Even now, recent developments point in opposite directions. On the one hand, Congress keeps nibbling away at diversity jurisdiction by raising the amount in controversy. And as we'll see in the next module, it has also provided narrower supplemental jurisdiction in diversity cases than in federal question cases. Yet on the other hand, the Class Action Fairness Act of 2005 has expanded diversity jurisdiction in an effort to get class actions with national implications into federal courts and out-of-state courts. Okay, so let's walk through the diversity statute, which is found at 28 U.S.C. Section 1332. The big point here is the same point that we just made with respect to the federal question statute. The diversity statute does not exploit all of the constitutional power created by Article III. Article III allows for federal courts to hear lawsuits between citizens of different states. That has been interpreted to mean that for constitutional purposes, minimal diversity confers on federal courts the constitutional power to hear the case. Thus, the Class Action Fairness Act says that so long as there's at least one plaintiff who is diverse from one defendant and the amount in controversy is satisfied, the statute specifies $5 million as the amount in controversy, a federal court can hear the case. Under the Constitution, minimal diversity suffices. The presence of one plaintiff who is from a different state than one defendant satisfies constitutional requirements. However, and this is important to understand, 28 U.S.C. Section 1332, which operationalizes the grant of diversity jurisdiction in the Constitution, the statute imposes more rigid requirements. It has been interpreted to require complete diversity, not minimal constitutional diversity. Now, what does complete diversity mean? Online student? Jane?
It means that all of the plaintiffs have to be from different states than all of the defendants.
Okay, complete diversity requires that there be no overlap between the citizenship of the plaintiffs and citizenship of the defendants. The statute is to be applied literally according to its terms. Do not disregard the plain language of the statute simply because you believe that the case is one where the diversity rationale ought to permit a federal court to assert jurisdiction. If the case does not strictly fall within one of the four categories in 28 U.S.C. Section 1332A1, 2, 3, or 4, there is no diversity jurisdiction in federal court, period. Even though there might be constitutional power for a federal court to hear the case because minimal diversity was satisfied. Okay, so let's take a look at the statute. Section 1332A says, the district courts shall have original jurisdiction of all civil actions where the matter in controversy, and now underline this next word, exceeds the sum or value of $75,000. It must exceed that amount. So if the complaint states a claim for $75,000 and meets the requirements of the diversity statute in other respects, the federal court does not have the power to hear the case. It must be $75,000.01 or more. In other words, the amount in controversy must exceed $75,000. and do not take interest into account and do not take the costs of the action, including attorney's fees, into account in determining that amount in controversy. Okay, so as we've just noted, 1332A1 says that there can be no overlap of citizenship on either side of the V. There must be complete diversity. Even though the same phrase that we see in 1332A1 has a different meaning in the Constitution, which again has been interpreted to require only minimal diversity. 1332A2 says that there is jurisdiction in lawsuits between citizens of a state and citizens or subjects of a foreign state, except that the district courts shall not have original jurisdiction under this subsection of an action between citizens of a state and citizens or subjects of a foreign state who are lawfully admitted as permanent residents in the United States and are domiciled in the same state. Now, what does that mean? What's the practical effect of that subsection?
It means that lawful permanent residents are treated as being from the state where they are domiciled because they aren't citizens.
Good. That's a lot of words that stand for the proposition that somebody who is lawfully admitted as a permanent resident of the United States is to be treated for diversity purposes as a citizen of the state where they are domiciled and not as a citizen or subject of a foreign state for purposes of 1332A2. By the way, Section 1332A2 and the grant of jurisdiction that it confers is known as alienage jurisdiction. Okay, on to 1332A3. That subsection provides for jurisdiction in lawsuits involving citizens of different states and which citizens or subjects of a foreign state are additional parties. And then finally, 1332A4 provides for jurisdiction in lawsuits involving a foreign state as plaintiff and citizens of a state or different states. Now, for individuals, where does a person's citizenship lie?
Where the person is domiciled.
Good. Now, what about corporations?
They can have two, where they're incorporated and where their principal place of business is.
Good. As Jane said, human beings are citizens of the state in which they are domiciled. Corporations, though, can have up to two states of citizenship, the place where they are incorporated and their principal place of business, if that is in a different state. All right, let's go back to the Mosley case for a moment. Recall that there was no jurisdiction in the federal court in Mosley 1 because there was no diversity jurisdiction. And, as Mosley held, there was no federal question jurisdiction because the federal issue only arose as a defense. So what if the Mosleys had been citizens of Kentucky and the railroad was incorporated in New York? Would they then have been entitled to sue the railroad in federal court under diversity jurisdiction? What do you think? Lisa?
In that case, I think so.
Not quite. What else would you have to know before you could answer this question?
I'm not sure.
What is different about a corporation's citizenship from an individual citizenship?
Corporations can have two. So I guess we'd have to know where the railroad's principal place of business is, right?
Good. And what might then cause a diversity issue?
Well, if the railroad's principal place of business is Kentucky, then there would be no diversity jurisdiction, right?
That's right. Does everyone understand that? Lisa, can you make it even clearer? Why wouldn't there be diversity?
Because it wouldn't be complete. Because the plaintiff would be from Kentucky and the railroad would be from Kentucky and New York. So there's overlap on both sides of the V.
Exactly. Very good. Okay, so that's enough of an introduction to diversity jurisdiction. In the next lecture, we'll review the Redner case, which emphasizes the need for the case to fit into one of the four categories of Section 1332A, 1, 2, 3, or 4. Then, in our last segment, we'll go through the notes and problems that follow the Redner case.